You're trying to avoid saying that she lied about the sexual encounter. We call page 4. This is case number A22-859-490C. This is Brittany Robertson and Wesley Robertson versus Kody Gorden et al. Could I have, once everybody comes up front, and Leo, we may need additional chairs at defense counsel's table. Sure. I think we'll have maybe at least 3 sets of defense counsel, perhaps more. We're here today on a motion for Rule 11 sanctions filed by defendants Kody Gorden and Tigers Baseball LV LLC for defendant Michael Stiles and for defendant Fraser Inouye, if I'm pronouncing that correctly. Inouye, thank you.
I struggle with it as well, though, Your Honor.
We also have a counter motion for sanctions filed by plaintiffs Brittany Robertson and Wesley Robertson. Let me go ahead and get appearances of counsel.
Good morning, Your Honor. This is Bre'Ahn on behalf of plaintiffs Brittany Robinson, Wesley Robinson.
Okay, let me get appearances of defense counsel in the courtroom.
Good morning, Your Honor. It's Jeremy Holmes on behalf of Kody Gorden and Tiger Baseball LV Inc.
Okay, good morning, Mr. Holmes.
Good morning, Your Honor. Louis Gazda and attorney Lauren Young on behalf of Michael Stiles.
Okay, good morning, Mr. Gazda and Mr. Young.
Your Honor, Matthew Friedman, 11571, on behalf of Fraser Inouye. I know he is present, as were all of our clients momentarily. Moments ago, I don't see him here now, but I'm assuming he's walking right in here.
That's fine. We can take a few minutes. Are your clients in the courtroom as well?
Yes, ma'am. This is Brittany Robinson and Wesley Robinson are also present in the courtroom.
All right, good morning, and good morning to the other parties here. Do we have anybody on blue jeans?
Your Honor, I think we need to make one more
I'm
appearance
sorry,
here.
I'm also making an appearance. My name is Bailey Reese on behalf of ADJ Baseball LLC, doing business as Rawlings Tigers.
You from Mr. Backus's office?
Yes.
All right, good morning.
Good morning.
Thank you. Do we have anybody on blue jeans?
Good morning, Judge Dale Hayes, bar number 90556, observing on behalf of Kody and Tigers Baseball.
All right, good morning, Mr. Hayes. Let's go ahead and wait for, I think we have some late entrants. All right, if any clients walked in, could their counsel introduce them?
On the far left here is my client, Kody Gorden.
All right, good morning.
In the middle is Mr. Young and I's client, Mr. Stiles.
Good morning.
Closest to the aisle, Your Honor, is my client, Mr. Inouye.
All right, good morning. Okay, so I've read everything several times. Let me tell you where I'm at. So I have the Rule 11 sanctions motion that's filed by the 3, what I'll call the 3 sets of defendants. Defendants Kody Gorden and Tigers Baseball, and by the way, you all can sit down. Defendant Michael Stiles and defendant Inouye. I'm going to generally refer to the motion as Gordon's motion, but I recognize that the motion was filed by more than Mr. Gorden. I will say this, though. If parties file a collective motion, I really prefer you file a collective reply. I understand why you felt constrained not to do so in this instance. I will also say this. Everyone needs to follow the local rules on exhibits and dependencies, particularly if you're coming to court to assert that your opposing counsel has violated the rules. When you file, hundreds of pages of exhibits, I really need those, properly done in an appendix. But let's set that aside because it's neither here nor there now, and let me address the motion and the problems I have with it. So the problem I have with Mr. Gordon's motion is that it really, at the end of the day, is asking me to weigh the evidence. And in fact, at certain points of the briefs, there is literally a request for this court to weigh the evidence. And that's not my job in this case, unless and until this case goes to a bench trial. Okay? And I assume, I haven't looked, but I assume there's been a demand for a jury trial. Rather, what my job is under the Rule 11 standard is to determine whether the Robertsons' counsel of record performed a reasonable inquiry under the circumstances, and determined in doing that inquiry that the factual contentions in their complaint either have evidentiary support, or, if stated on information and belief, will have evidentiary support after discovery. On that point, I can't help but note that it takes until page 30 of 34 in Gordon's motion for Gordon to even address the issue of counsel inquiry. And when that issue is addressed, Gordon appears to cite 9b for the proposition that the Robertsons are somehow held to a higher pleading standard because their allegations can damage an individual's representation. That is not what Rule 9b requires when fraud is not pled, and fraud is not pled here. And frankly, the assertion, I find the assertion a bit mind-boggling because it would then require almost any lawsuit to be pled with particularity, because almost any lawsuit can be construed to damage an individual's reputation by the mere allegation that the defendant broke the law. So the way I read the argument, but the argument that it seems to me that Gordon is really making is that plaintiff's counsel could not have conducted an investigation because any investigation would have revealed text messages sent by the plaintiffs themselves that reveal their allegations to be false. But that argument reveals the very problem that I have with the motion. It asks me to weigh the evidence. I have to assume, consistent with plaintiff's counsel's declaration, that counsel communicated with his clients. And while I don't know what the content of those communications were, nor am I asking for the content of those communications, because that would reveal the attorney-client privilege, I can draw a reasonable inference that whatever those communications were, they led to the allegations that are in the complaint. And it seems to me, therefore, that the communications would form the basis of plaintiff's anticipated testimony, in particular here, Ms. Robertson's testimony, where I presume she is going to say, hey, I felt manipulated into having this affair, and I didn't consent to the sexual encounter. Also, plaintiff's counsel makes the very point in their opposition that ran through my mind during the entire time I was reading these briefs. Even if Ms. Robertson's and Mr. Gordon's communications leading up to the sexual encounter were consensual, that really doesn't matter if Ms. Robertson didn't consent to sex or even withdrew her consent to sex during the encounter. I'm sure Mr. Gordon disputes that narrative and insists everything, including any sexual encounter, was consensual. But that he said, she said dispute, that's just inherent in many sexual assault cases. And we don't tell the claimed victim in those cases that he or she is lying merely because they were in a consensual relationship leading up to the sexual encounter. So again, by filing this motion, Mr. Gordon is asking me that just by weighing the veracity of allegations and anticipated testimony against the text, which, by the way, I think there's an admission by everyone that those texts that I received don't even comprise the full universe of texts, given that many texts, understandably, were deleted during the course of the affair. But he's asking me to weigh the veracity of Ms. Robertson's allegations against those texts, and then to find that there's been a Rule 11 violation. Now, I'll tell you, I read all the texts, all 114 pages of exhibits that were attached to the motion, and over the 200 pages of rebuttal exhibits. And I'll tell you that even if I were to weigh the evidence, I don't think they're as compelling as defendants think they are. I agree that Dr. Robertson threatened this lawsuit, but that in and of itself, frankly, that's not illegal. And I have to imagine Dr. Robertson's texts were born out of anger, anxiety, frustration, and severe distress by finding out that his wife had had an affair with Mr. Gordon. So I'll tell you, I'm going to let you make your record and I'm going to let you argue, but I'm not inclined to grant the Rule 11 motion. But I have been moved off my position before. And I don't hold oral argument in cases unless I think I can be moved off my position. Now, let's talk briefly about the counter motion, because I just want this argued at the same time. And that's the counter motion to seal and for sanctions. On sealing, or rather what's really being requested is redaction. The court agrees that, look, I'm familiar with the federal rules, including the local federal rules, and there is a local rule in our federal court compelling the use of a minor child's initials instead of the child's full name. But there's not a corollary rule, at least not one I could find, in state court, whether that's under the Supreme Court rules for sealing or the policy for handling presumptively confidential information. I do understand the concern of using a minor child's name here. At the same time, I have to say, I question how concerned plaintiffs actually are about defendants' use of their child's name when they didn't file an emergency motion to seal or redact. These motions have been sitting out there since December, okay? So plaintiffs need to make a good case for why the court should now require the use of initials. And if there's an argument that this child leads a private life, I want a representation from counsel that there's no social media posts about this child to include his name. Suffice it to say, the sanctions alone are going to be denied on use of the child's name because there's just simply no rule that compels it. As for the phone numbers, I'll just tell you now, I'm not going to require the redaction of third-party phone numbers. There's nothing inherently private about disclosing a person's phone number. And in fact, you know, I think most of us in this room can remember there used to be something called the phone book where everyone's number was published at one point in time. So that part of the motion, you can argue it, but I'm going to deny it. So this is defense motion. Who wants to start?
Your Honor, on behalf of Kody Gorden, I'll start. In light of the court's representations and seeing a disinclination to be weighing evidence today, what I'd like to point out is...
Well, tell me why I'm not weighing evidence.
Well, in some ways, I think that there is some credibility issues that we raised, Your Honor, that if Your Honor does not want to weigh evidence, then I think that's inherent in some of what we asked as far as the claims and the text messages showing that there was a consensual relationship. Statements made by the plaintiffs that indicate that this was consensual and kind of tip their hand as to what the motive really is here.
Well, Mr. Holmes, if you're conceding that your motion inherently asks me to weigh evidence, and I assume you know it's not proper for the court to weigh evidence at this stage, why did you file your motion?
Well, Your Honor, that's not exactly what I'm asking. There's portions of it where I think that's where the motion's led in responding to the reply or responding to the opposition is where things led. But really, what I'd like to point out, Your Honor, is in the opposition where the plaintiffs had their opportunity to show, here's why we made these claims, here's the investigation, here's what we found.
How are they supposed to do that without revealing their attorney-client work product and attorney-client communications?
Well, according to them, they reviewed a bunch of messages and interviewed multiple witnesses. None of those were named. There's no documents that have been disclosed that show any threats of...
But you're not at the discovery stage.
I understand that, Your Honor, but at this stage, we've put forth this motion saying that they have no reasonable grounds. They put forth no reasonable investigation. And in response, all they've done is show, here's messages showing that they had an affair. Here's messages showing that they were talking. There's no evidence of any kind as to any threats, harassment, anything that they would reasonably put forward at this stage to say, here's why we have a good faith basis to make these claims. There's no evidence of any kind.
Why wouldn't Ms. Robertson's testimony on those points be enough? I mean, testimony is evidence.
That's true, Your Honor. The problem with that is that her testimony is belied by the record itself. And I think that's, again, where we get into the issue of weighing credibility and weighing evidence. But even then, her statements, again, Your Honor, I'm trying to avoid where I think this ultimately led in the weighing of evidence, but...
You're trying to avoid saying that she lied about the sexual encounter.
Your Honor, even if... We obviously believe that that's not true, but she has her own reasons to believe, and you're correct that you can be consenting in a flirtatious relationship and an affair up to that point and then not consent to a physical encounter. But that's one of 11 claims that they brought. There's no evidence of any kind to support any of the other claims. There's no conspiracy. Like I said, there's no harassment or anything like that. And effectively what plaintiffs are asking the court to believe is that plaintiff is willing to do anything to keep her son on a team with people that she alleges are rapists and criminals. And it's simply, it's not believable. And that's why we argue that any attorney that did a reasonable inquiry into these facts would have seen, all right, there's more to the story. Something's not right here. And again, they argue that the premise of this case is that 3 grown men inspired and harassed this one woman to send naked pictures, naked videos, and to sleep with Kody Gorden a single time.
You don't think 3 grown men can do that? Were you a part of a fraternity?
I was not, Your Honor. But I'm not saying that doesn't happen. I'm just saying that's the premise here. It also is that the leverage that this was based on was an 8-year-old's Little League career. And that the threat was that he was going to be taken off his team, something they voluntarily did later and were able to find him a comparable new team in days. Something that was apparently not so much of an issue that they couldn't find him a new team. But for some reason, this led to her lying about telling her husband that a rape was a consensual sexual act for 9 to 10 months in the privacy of their own home, to where it simply strains belief and strains credibility. And that's why we believe that any reasonable inquiry into this and saw those messages, interviewed the witnesses that they claim to have interviewed. There's no names provided. The only name provided, I think, is Mr. Smoot, and he came out and said that's not true. He came out and said that there was no rumors going around. The reason I asked this question was because they had abruptly pulled him off the Tigers team, not because of any conduct of the defendants here. Any investigation would have shown that they needed to dig deeper.
And then how do they, even if they had dug deeper, because now, whether or not they've dug deeper or not, you've produced all the, what you call the counter evidence, the stuff that you think they should have discovered, right? Now, they have to weigh that against their own client's narrative and version of events and anticipated testimony. What compels them to believe the evidence that you've provided versus their own client's testimony?
Evidence testimony, and that is something that we tried to argue. And I know, again, we don't want to get into weighing evidence, but if they had truly viewed those messages and reviewed the whole course of communication and talked to all these people that they claim they talked to, I can't fathom why this action was brought.
Anything else? Right.
Good morning, Your Honor. Again, Louis Gazda and Lauren Young on behalf of Stiles. I appreciate your hearing this today. When a party makes a scandalous allegation, that scandalous allegation that's so severe that it harms somebody's reputation in the community, that it costs them employment opportunities, there must be, or there had better be, evidence to support those allegations. That's why, Your Honor, we joined in a Rule 11 motion, because a Rule 11 motion forces and puts the burden upon the opposing party to come forward with some evidence against that Rule 11 motion, some sort of evidence to show that there is some merit or some support for the allegations within their pleading. After we filed our motion, Your Honor, I anxiously awaited the opposition. I wanted to see what evidence, if any, there was against my client, Michael Stiles. And I received their opposition. And I looked at the affidavit, the declaration of Plaintiffs' Counsel Marjorie Hoff. I reviewed the recital. I reviewed the declaration of Mrs. Robertson. And I reviewed also all of the texts and exhibits that were attached in addition. And, Your Honor, there was not one piece of evidence against Michael Stiles. That's what we're here for, and on my behalf, Your Honor. The declaration of Mrs. Robertson doesn't even reference Michael Stiles until paragraph 65.
Will you give me a moment to pull that up?
Certainly.
Point me, just because I have so many documents open between all the parties, can you point me to exactly where that is if you have it in front of you?
Let me just pull it here. I believe isn't it the first exhibit? Yeah, it's the first exhibit to their opposition is her declaration.
Your Honor, it's Exhibit 2.
Pardon me, is it two? I'm sorry, thank you.
Okay, I am there.
And paragraph 65.
So what paragraph?
65.
Okay,
Okay, so within this paragraph, Mrs. Robertson is discussing part of her relationship with Kody Gorden and is fearful that he, Mr. Gordon, was sharing the communications and photos with Mike. That's what the statement essentially says. So she doesn't say that Mike did anything wrong, and even a review of that statement cannot be interpreted as some sort of evidence adverse to Michael Stiles. She doesn't say he did anything. Simply viewing something, simply seeing something, if that even occurred, is not evidence of a tort. It's not evidence of wrongdoing. Seeing something that may be displayed by somebody else is not actionable. At paragraph 67, Your Honor, this is when they're talking about Mrs. Robertson going to the bar. And what she says within paragraph 67 is that Mr. Gordon was calling her, quote, to come hang out with him, end quote, and that he was using his phone and Mike's phone. That's really the entirety of that allegation against Mr. Stiles, that he used Mike's phone. Using somebody's phone is not actionable. That's not a tort. There is nothing evidentiary-wise that supports an allegation against Mr. Stiles because he let somebody use his phone. Next paragraph is 74, Your Honor, when she discusses this. And this is when they're actually in that bar and they are allegedly, rubbing one another's genitalia. Again, there's no evidence presented in that declaration that Mike did anything, that Mike said anything. There's no allegation in that paragraph saying anything about Mike in regard to doing any wrongdoing. The next paragraph is 75. And the best they have there is he pretended not to see. Whether he saw it or not is, again, not a tort. It's not actionable. It's not evidence against Mr. Stiles. In the next several paragraphs, 76 through 83, Your Honor, this is when Mrs. Robertson indicates that she was leaving the bar and that Mr. Gordon followed her outside. And it's at this outside time that the alleged sexual assault occurred. If you notice from review of those paragraphs, Your Honor, Mike wasn't outside. Only Mr. Gordon followed her outside. She doesn't say Mike said anything, did anything, knew anything. She doesn't even allege that Mr. Gordon said anything or did anything to alert anyone, including herself, that a sexual assault was about to occur. There's no evidence in that indicating that Mr. Stiles did anything wrong. Paragraph 85 is in regard to a textual conversation, and she picks out the words, quote, good to see you, end quote. That's not evidence that supports any claim. When a person is going to use words as a basis for their claim, we have to reasonably interpret those words. We have to give reasonable meaning to them. And I submit to you that no reasonable person at any time could say the words good to see you would be indicative of any wrongdoing. If we don't cherry pick those words and we look at the entire conversation, what we see, and I'll read that to you. It's actually attached as Exhibit I to our motion, but I'll read it to you. And I'll reference who says what, Mike being Mike and Mrs. Robertson being Mrs. Robertson. So Mike, good to see you. Mrs. Robertson, you too. Sorry to run so fast. Mike, no worries. We'll have to get you to have a drink next time. Mrs. Robertson, yes. Mike, soon I'm buying. Yet Mrs. Robertson alleges this is some sort of evidence. This isn't evidence of any wrongdoing. For there to be evidence of wrongdoing, she would have had to have made different allegations. She would have had to have said that, one, these words indicated an intent to commit either a crime or a tortious act. She would have to indicate that there was apprehension of imminent harmful contact, and there is no such allegation. She doesn't mention this anywhere. These are the elements of a tort, and it's not mentioned. She doesn't say she was in fear of being harmed, that there was offensive contact that was going to occur. That these words don't rise to that level. They can't even reasonably be interpreted to indicate that. That conversation is not evidence of any wrongdoing on behalf of Mr. Stiles. And then in paragraphs 97 to 99, Your Honor, she talks about that Mr. Stiles and herself would have various conversations, and that she says that Mr. Stiles would direct the conversations, quote, all the time, end quote, towards topics involving Mr. Gorden. Even assuming that's true, that's not evidence of wrongdoing. If you want to talk about somebody.
Let me just stop you for a second. I pulled up the complaint during your argument only because we do need to talk about the allegations in the context of the claims that have actually been made against Mr. Stiles, which isn't, my understanding is it's not assault of any sort. Isn't it conspiracy and defamation?
Okay.
I mean, I'm asking, there are claims made against your client.
Those are some of them.
Yeah. But you agree that he has not been, there's not a claim of assault that's been made against your client, right?
That's what I would like to believe.
I mean, I'm looking at the sixth claim for relief, and it says assault against defendant Kody Gorden and or Doe and Roe defendants.
Yes.
So
some of her other paragraphs within the complaint, when they talk about the assault, says defendants in plural. So it's a little vague in that regard.
Okay.
But just because somebody may steer a conversation toward a topic, you then must allege, you must have information, you must have some evidence that's presented. This is what Rule 11 requires, to come forward with some evidence to show that there is some merit to the allegations in the complaint. What support
some evidence, or first of all, I don't see where in Rule 11 it actually says that. I think what Rule 11 says is it's about an inquiry into whether or not that the allegations are either supported by evidence or after a reasonable opportunity for discovery will be supported by evidence.
Yes, but you have to say what it is in your opposition. And in their opposition, Your Honor, they say nothing. They come out with nothing. There's no evidence that they're pointing to towards Mr. Stiles. And that's the problem that we have here in regard to Mr. Stiles, is where's your evidentiary support? Based on her testimony, essentially, in her declaration, there is nothing. I mean, even when we look at paragraph 116, the one right before the end, the second to the last paragraph, where the last paragraph says everything's true and correct to the best of my knowledge. She says in part in that paragraph, Your Honor, that Mike and others were disseminating personal information about me to others on the 14U team that Kody Gorden had been the coach of prior to his resignation, and that there were wild rumors going on about Kody being, quote, caught in bed with a player's mom, end quote. So this declaration made under penalty of perjury, with the defendant having to come forward with some evidence, some evidentiary support you're supposed to show. This doesn't show any evidentiary support. What this is, Your Honor, is hearsay upon hearsay. It doesn't have any indicia of accuracy or reliability. It is a self-serving statement, Your Honor, with nothing more to it. Even plaintiff's sworn testimony says, other people told her. She doesn't say, other people told me this was about me. What she says is, it was a player's mom. She never says that they swore it was you. She never said, are they asking if it was me? She says it was
about her.
She said, no.
I was informed by other parents that Fraser, Kody, Mike, and others were disseminating personal information about me to others.
Mm-hmm. And when we continue it, it says, and that Kody was caught in bed with a player's mom.
I mean, I think there's a reasonable inference here, including by the declarations you all submitted, that people knew that there was something going on between Mrs. Robertson and Mr. Gorden, right? So who else is the player's mom going to be?
I don't know if there are others, Your Honor. I have no idea. In fact, if we were to look at some of Mrs. Robertson's future texts, she even talks about to Mr. Stiles, are there others? She wants to know if there are other people that he is having an affair with. So I don't think that we can read that into this, Your Honor. So when we look at their obligation to come forward with some evidence, some evidentiary support to provide something that is completely and never would be inadmissible, hearsay upon hearsay, without any accuracy, there is no named person in this. It's a player's mom. She doesn't even swear that it's her. So when you look at this, it is not truly evidentiary support of the allegations.
Can you point me to some legal authority that says they have to come forward at this stage with evidence as opposed to information that they received that after discovery, their allegations are going to be supported by evidence?
Well, Your Honor, the case of Bergman versus Boyce, it's a Nevada case. I don't have the cite for it, but it indicates that sanctions should be imposed for frivolous actions. And a frivolous claim is one that is both baseless and made without a reasonable and competent inquiry. A competent and reasonable inquiry in this case, Your Honor, would have provided names, identities, actual statements, a sworn statement, an affidavit from somebody. Yet we are completely lacking. We do not have a single letter, a single text, a single affidavit, a single statement, verified or unverified, indicating that Michael Stiles did anything wrong. Simply put, Your Honor, they have not complied with the requirements of Bergman versus Boyce or Rule 11, which says there must be evidentiary support.
But that's not what Rule 11 says.
It does say there must be evidentiary support.
It says that counsel made a reasonable inquiry that the allegations are supported by evidence or will be supported by evidence after an opportunity for discovery. You're just asking me to completely ignore that second part.
Well,
we can look at Rule 11. Are you denying that that's what Rule 11 says?
No, I'm not. But what I am saying is Mrs. Hoff, or Miss Hoff, I don't know, indicates that she did make this inquiry, that she did do this. If you did do it, then present it.
Why?
What is it? Who is it? Because Rule 11 says you have to have evidentiary support for the allegations within the complaint. So what is the evidentiary support? It's your turn to show. It is your burden to show there is actual evidence. They didn't set forth any actual evidence against Mr. Stiles.
Okay, let me hear from your, I was about to say your co-counsel, but he's not your co-counsel.
Thank you, Your
Your
Honor.
co-defense counsel.
Strange kissing cousins, as it might be. I think I can offer a little elucidation from my client's perspective, because I do believe he is the most divergently situated. I think we sort of go in descending order of divergent situations here. My client, if you note, where he is involved is the notion of the dissemination, receipt, and sort of some type of a conspiracy. Notably, he's not actually named in the civil conspiracy, so I think that in and of itself is problematic because they maintain the claim despite actually naming him as being part of this conspiracy. I think Your Honor is correct. You don't necessarily have to be weighing evidence. We talk about the reasonable inquiry. I think what we need to look at, what was available, okay? Perhaps there's inquiry investigations that would be undertaken in discovery that wasn't available. What was available, Judge? Certainly, both plaintiffs' text messages were plenarily available to plaintiffs' counsel. The complete history of the communications between Mr. Robertson and my client, Mr. Inouye, as well as Ms. Robertson and my client, Mr. Inouye. We provided those. What's striking in those, Judge, and why I do think my client's dissimilarly situated, is that Mr. Robertson is the one who brings this to my client's attention in November of 2021. He is the one who says to him what's been going on between Kody and his wife, allegedly. He's the one who specifically requests that my client keep this confidential, which my client does. Notably, some 11 months later, when he's discussing this with my client, he actually says, and we quote this for Your Honor, "I thought you had talked to him about it." And he says, "No, I kept your confidence." This was readily available to plaintiffs' counsel and to plaintiffs. They knew Mr. Robertson was the one who was discussing this with my client, not my client and the co-defendants. They knew that Mr. Robertson has asked him to keep it confidential, and in fact, that he had confirmed that he has. He actually says, "Oh, I thought Kody would have told you." And my client says, "No, he didn't." So right there, okay, that set of text messages, Your Honor, absolutely available. I believe absolutely required in terms of a reasonable investigation. I don't know how, as a competent litigator, we don't at a minimum say to our clients, please give me everything you have and review them. And when the substance of those text messages clearly reveals that, at least as in for my client, Mr. Inouye, that he had nothing to do with this, even as far as Mr. Robertson, as he's pulling the child off the team, saying to my client, call Brittany to discuss it. Those are not the words of a litigant who at that point is convinced that his client has been much less sexually assaulted, but that my client has somehow been involved in a conspiracy to further this coercion.
But the conspiracy claim isn't actually alleged against him.
Well, it isn't, which is what's really more problematic, because it sort of is interwoven in there, and then it's sort of left out in the amended complaint. So I think that there's two categories, Judge. There's what was available prior to the filing. I think certainly in terms of those broad categories of text messages, all of the communications between Fraser and Mrs. Robertson were there. There's absolutely no indicia of what they're talking about. None at all. It is all absolutely club. My child's in club soccer, but it is very basic club sports communication, and that is it. Okay. The same is true of Mr. Robertson and my client, with the exception of the fact that it is filled with Mr. Robertson setting forth what his wife has done, casting aspersions. He's the one defaming his wife to my client. My client is never responding even in kind. In fact, my client is shocked, trying to help remedy the situation, and telling him that he will hold it in confidence, and doing so. And there is textual evidence that he did so. That Mr. Robertson is saying, oh, I thought Kody, as I said, I don't mean to repeat myself, would have told you. And he says, no, he doesn't even know that I know, my client says of Kody. Kody doesn't even know that I know anything about this. And that is contemporaneous with the inception of the filing. No, he doesn't even know that I do. So how could you then maintain reasonably when you have this in your possession? Excuse me, Judge, I'm suffering from a cold here. How could you reasonably maintain that my client was in possession of and furthering these communications when you yourself, Mr. Robertson, confirmed he had not even been discussed it with Kody and had kept your confidence? Okay? That's one set. I think the second set, Judge, becomes what do they have in their possession after receiving the safe harbor letter and the motion? What they have then is a very salient piece of correspondence between Kody, Mr. Stiles, and my client. And you will see my client has some very unkind words for Mr. Gordon. And I won't repeat them for Your Honor in court, but I'm happy to if you'd like me to. And basically says to him, I asked you if there was anything going on that could jeopardize my team. You told me absolutely not. I'm paraphrasing, okay? You need to man up and do something about this. You lied to me, okay? That is my client, I think, very clearly showing this court, again, available to plaintiff's counsel, available to, at least after the filing of the rule, prior to the filing, but once they had received the safe harbor letter and the draft motion, that there was actual textual evidence that my client, in and of himself, was shocked to know that anything had occurred. Yet they still file a complaint maintaining that my client was part of this, if not conspiracy, he was part of disseminating these false rumors or untrue rumors about Mrs. Robertson, and that he was somehow party to disseminating and sharing these photos. How that can possibly be when the conspirators are arguing with one another, wherein my client says, you lied to me and told me nothing happened. They had that in their possession prior to the filing of their opposition, prior to the filing of our motion, and chose to do nothing about modifying or altering their claims. In truth, it should have gone away, the claims against my client. That should have been enough under Rule 11. That should have been all they needed. Yet they still chose to move forward and do nothing to change it. That, Judge, while I understand that our clients may be dissimilarly situated, from my client's perspective, they had all that they needed. And they have simply chosen to drag my client along in this. My client is not exactly situated the same as these individuals. He's a professional CPA, owns a CPA accounting firm. It's a very different, the effect on his personal life, not to imply it has any less impact on these young gentlemen here, but it is severe and significant, particularly when the connection is so tenuous. When on the front end they had every bit of information they needed to know. Clearly, nothing in the communications with their clients would suggest that my client had anything to do with it. And then once they received the safe harbor letter, certainly knew that my client was very upset with Mr. Gordon, saying, you lied to me. I asked you about this. So how could both be true? How could he be in a present tense utterance, these extolling, how could you have lied, and at the same time have been part? And Kody says, you're right, you had nothing to do with it. I'm sorry, I was trying to minimize. It was a one-time thing. Your Honor, they had that in their hands and chose to do nothing with it. That in and of itself, Your Honor, I think is sanctionable under Rule 11. And I would submit to Your Honor, in my entire career, I think I've sent 3 safe harbor letters. I filed 2 of these motions. I've been in court exactly one time, and that's today. I know it is an extreme remedy. And I understand you're grappling with a lot of complex interest, and there are very different individuals situated at this defense counsel and defendants situated. But at least as informed my client, I think you have to strongly consider imposing a sanction there. They certainly had everything they needed to know to at least significantly tailor the allegations against my client, which they've chosen not to do, or in my opinion, release him altogether. And I would rest on that. I'm happy to answer any questions, Judge, but I do think you have what you need there.
You.
You're welcome.
All right, plaintiffs. Okay, wait. There's one more.
Yes, Your
Defense
Honor.
counsel, but I understand you're not in the motion, correct?
Yeah, correct. We did not join the motion.
Okay, very good. All right. Plaintiffs counsel.
Good morning, Your Honor. I want to kind of quote something that defense counsel said, and also, just inform the court of how this all came about. First and foremost, Marjorie Hoff has been a lawyer for over 20 years. So just how they understand the severity of this motion, they understand the severity of the claims that they're making, so does she. She has never had a Rule 11 motion filed against her. So just like this is their first time, it's ours as well. It's a very serious allegation to make, and we don't take it lightly. When this case was presented to us by my clients, we said the exact same thing defendant said, and I'll quote him: "There's more to this story, and something's not right here." That's exactly the impression that we got from what we were seeing. We reviewed hundreds of text messages that show things that directly contradict what they're saying, where they're pulling out 3 or 4 text messages from a page that is 13 pages long of an exchange and saying, oh, this is what she meant. Or most of the damning things in their motion is not supported by an affidavit. It's not supported by a text. It's not supported by an Instagram post or a Snapchat or a Words with Friends post. They're not supported by anything. So in terms of the allegations of the investigations we made, that is specifically laid out in our declaration as to what we did in support of this case. We spoke multiple times to our clients, had them come in, interviewed them, spoke to Kendall Wayne, Brittany's sister, went through hundreds of text messages. We did not file this lightly. As a woman, filing or accusing someone of sexual assault is not a light matter for me. We do not play about those type of allegations. So every allegation made in our complaint was made thoroughly and as a result of our investigation of such. And like you pointed out, under Rule 11, we have laid out in our opposition that the evidence will likely show through investigation and discovery more support for the claims that we made. Let's be clear, we have support for the claims that have been made, and investigation and discovery will show more support of such. Defendants have mentioned reputation multiple times. Mr. Robinson is a well-esteemed pediatrician in the community, one of the best here. We're talking about reputation. Brittany is putting all of her business on the line here by filing this complaint, and she understands that. But she wants justice for what happened to her. So we're talking about reputation like they're the only ones that are suffering from this. By her bringing this claim, she is also putting her reputation on the line. Look at how they're talking about her.
And she has a defamation claim.
And she has a defamation claim.
So reputation is inherently at issue in this lawsuit.
And look how they're speaking about her. Look how they're talking about her, And I think you pointed out one of the most important things here. I can say yes Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, but if on Sunday I say no, that means no. And so the consensual relationship here, it's not relevant. It really just isn't. We're also talking about, counsel made mention of, we're talking about an 8-year-old's career. I'm sure LeBron James was 8-year-old at one point and had to, play through his life until he made it to the NBA. So yes, we may be talking about a child's career, but it could turn into a professional career. So it's serious for his parents. They're talking about credibility. Credibility is for the trier of fact. We're not here to talk about anybody's credibility. We're going to put these people on the stand, and a jury will determine if they're liars. A jury will determine if they're telling the truth and make a decision. It's not for us to decide. They made the statement that Brittany told Wesley that that the sex was consensual at first, and then later told him it was sexual assault. Brittany will testify she never told him it was consensual. They also talk about, we never identified any witnesses or we provided a declaration of Kendall Wayne, which they provided text messages and a declaration from Alexis Gordon stating that she had this conversation with Kendall Wayne, but then in the declaration by Kendall Wayne, she specifically states that's not what she meant by the text message. This is what I mean by pulling things out of context and support. In addition to that, addressing Mr. Stiles, Mr. Stiles was well aware of the dealings going on. That's evidenced by all of his communications with Brittany, where he's encouraging her to continue these dealings and to continue talking to Kody. So to now state that he has nothing to do with it, he's literally sitting across from the table, watching them allegedly grope each other, but then he has nothing to do with it and he didn't see anything.
My understanding of those allegations are that, and again, these are just allegations at this point, but my understanding of the allegations involving Mr. Stiles is that you're saying that he and Mr. Gorden worked together on that day where they went to, I think it was PT's Pub, and they worked in concert together basically to compel Miss Robertson to attend that meeting at PT's Pub, during which the sexual encounter occurred in the back alley, correct?
Correct. And to get the evidentiary support for that, we need subpoenas from his cell phone carrier. We need his deposition testimony to say, what did you and Kody talk about that day? What was the plan when you woke up that morning? Oh, we're just going to play golf and then we're going to invite Brittany? We don't know. How am I supposed to get a hold of the text messages between Michael Stiles and Kody Gorden on that day? He was present on the day of the sexual assault. For him to say that he just has no involvement here is definitely a stretch. And their claim that the basis of our claim are words, it's not the basis of our claim. There's text messages and support for Brittany's claims here. For them to say that she never asserted the elements of a tort claim in her text messages with Mr. Stiles, I'm pretty sure that's not supported by any case law, that you have to assert the elements of a tort claim that you plan to make in the future to a text message to the person you plan to sue. Pretty sure that's not supported by case law or any other statute. I think the defendants are confused in general about the claims that are specifically made against their specific clients. So we've had a lot of argument here about claims that are not made against their clients. We're not saying that Michael Stiles assaulted Brittany. I think we can all agree here that that didn't happen. And if it was clear, I just made it clear for the record. And I think in large part here, there's a huge double standard. Here they want plaintiff, they're claiming that all the plaintiff's evidence deals with hearsay, but so does theirs. They're claiming that, we haven't supported our opposition with any declarations or anything. Well, they haven't really either. There's declarations from people who are specifically having an interest in this, and they say, oh, well, there's two people who don't have an interest, but both of their statements are very problematic in the grand scheme of things. You're saying that there is no dissemination of images, but you literally have a witness who states in her declaration that she screenshot the Instagram account and sent it to somebody else.
I apologize. I have search warrant duty.
No worries. And I think under NRCP 11B3, the main fact here in terms of Mr. Stiles, I think we have enough to maintain our claim thus far, and there is enough evidence to show that there will be likely more evidence, a slew of more evidence. I think we can all agree this is the tip of the iceberg. We haven't done one subpoena. We haven't done one deposition. I anticipate there being thousands of pages of text messages and records and subpoenaing everybody's social media accounts, all of those things. We haven't had a chance to do that because they haven't answered the complaint. So discovery hasn't opened, but that's neither here nor there. And then last but not least, Mr. Fraser. Defense counsel talked a lot about the text message that Fraser sent Mr. Gorden after the complaint was filed. Of course he was mad. He got sued. I don't understand why someone wouldn't be upset about that. So that text message is unconvincing, especially since it's after the complaint was filed.
My understanding of a defamation claim, at least from Ms. Robertson's declaration, is that the defamation claim is based on rumors and innuendo about her and her relationship with Mr. Gorden that she alleges Mr. Fraser was involved in spreading.
Correct. Brittany has been told specifically by people on the baseball team and affiliated by the baseball team that Fraser was repeating the fact that her and Kody had something going on, that she was known as the hot doctor's wife. So if you're not participating and have nothing to do with this situation, why are you talking about it? Why are you spreading rumors about it? Brittany deserves to be able to get his text message, his social media accounts, his text messages with Kody before the complaint was filed. We see one text message between him and Kody, which is after, and of course he's upset. That it's not evidence to show that he had nothing to do with this. In addition to that, absent a subpoena, if text messages are deleted, how is plaintiff's counsel supposed to get a hold of them? We obviously need a forensic analysis on their text messages to get the deleted text messages to really show the evidentiary support. However, the little that we do have shows that the claims are valid and they were not filed frivolously. And again, they're arguing claims that were not brought against them. I would direct them back to the complaint and pay attention to what was filed against their particular clients. In this particular case for Mr. Fraser, what was filed against him was the defamation and dissemination of private images and information. In that regard, we feel that he was involved. Brittany has been told specifically by people that have told her that they got that information from Fraser, not Kody, not Wesley, from Fraser. So, I mean, I think Your Honor has made her position pretty clear. And on those points, Your Honor, I'll rest. And unless you want to address the sanctions.
You want to talk about your sealing motion?
Sure.
Look, my real concern on that is that I agree with you conceptually that
Yeah. And it's not so much that we want sanctions. It's just about these kids. This is very delicate subject matter, and we're throwing children's names into this situation that have nothing to do with it. In all of their oppositions to the motions, they were not opposed to redacting or stealing their names. I just asked that we stop using children's names in these serious pleadings about this serious event. I just think it's inappropriate. I understand that there is no local rule. However, I just think that we should all agree that we're not going to use children's names in our pleadings going forward. We just govern ourselves accordingly. And I don't know if we need to enter into a protective order in that regard. I'm happy to do that. But I just think it's inappropriate to just continually mention all of these children's names when they have absolutely nothing to do with the allegations made herein.
I don't disagree with that concept. My question is really, if this was so important to your clients, why didn't you file an emergency motion to redact or seal on OST when the motion was first filed? This information has been out there for months, and I don't know if, people could have downloaded these motions. I mean, as you know, we have media on Blue Jeans today. I assume they have downloaded the papers. It's not as if I can claw that back.
Right, and that's true, Your Honor, and that is definitely a course of action we could have taken in that regard. But I mean, hindsight's 20/20. The only thing we can do now is protect them moving forward. And because their names are so heavily used in these pleadings, we just ask that going forward, they're not anymore.
So you're asking that the initials be used, correct?
Initials be used, or just refer to them as children.
And I assume you're not just asking for the Robertson's child. I assume throughout, if this case moves forward, we're going to be talking about so-and-so's mom or so-and-so's dad.
Yes, and I believe there's some other declarations that they provided that of parents of other children's moms where they mentioned their child's name in the declaration, and so those as well. And then in terms of
if their own parent is fine with their kid's name being out there in their own declaration that they know is going to be filed, I'm not gonna be, no pun intended, paternalistic about that.
my concern is the child. Okay, so I'm 8 right now. When I turn 21 and I search my name on I had no dog in the fight. No one advocated for me in that regard to have my name still, so that I'm not brought up in any type of nonsense when I'm a grown person.
That's true. There's a big debate about that, about whether or not parents should be posting on social media and all sorts of stuff.
And then the phone numbers, if your honor is not inclined to have those redacted, I do think it's a privacy concern. I don't think that I wouldn't want my phone number posted on the internet. But
probably already is, that you don't know about.
Maybe, but not purposely in a motion I pressed file on. So, but not your honor, I'll rest.
All right, thank you. Replies, briefly. Actually, I have Mr. Draskovich in here. Let me bring him forward. I'm going to pause this, and I'm going to go to, because I've seen you in here for a while, Mr. Draskovich. I'm going to go to, because this is going to be quick.
It is.
All right. So I'm going to go to page 5 in the matter of the petition of.
I left another court to appear before Your Honor. I was afraid of being late.
Okay, it's no problem at all. Thank you, Mr. Draskovich.
Thank you so much.
Okay, let's go back to Page 4, case number A2285949OC, replies. Let's limit it to about, 3 or 4 minutes each.
Each? All right, I don't think that'll be a problem. So, I just kind of got up here slightly that they did a reasonable investigation. They've uncovered a slew of evidence, and my question is, where is it? It wasn't attached to their opposition. That was their purpose. The only evidence they provided, the notion that nobody's arguing, that they were flirting, or that Kody and Brittany were flirting. No evidence of any extortion. Everything that we're claiming, they haven't produced that. I haven't seen it. This is their opportunity to do. Did not do that. They say that we make a bunch of kind of evidence. Everything in our motion is either cited directly to, supported by the verified statement of Kody Gorden, which was attached to the motion. So that is also not true. Stating that there's no aspect of the consensual relationship relevant. I agree that the consensual relationship is relevant to whether there's consent at the time of the alleged assault, but it's very relevant to the allegations that he was extorting her, harassing her. A consensual relationship between.
By the way, it's also relevant to the veracity and the credibility of the plaintiffs. Like, look, the consensual nature of the relationship is relevant. And it's relevant to whether or not an assault occurred, right? And whether or not consent was withdrawn. Absolutely, it's relevant. But my point here is that the mere fact that it was consensual does not mean that the sexual encounter was consensual. So I think we're on the same page, right?
Yes, I agree with that. And what I'm saying is that they're saying that she was threatened and extorted, and that's the only reason she was talking to him was this fear. But consensual nature shows that that's not true. You're not consensually engaging with someone if you're fearful of them, if they're extorting you. This shows that they were playful, they were chatting, there was no threats, there was no fear. There's no evidence to support any of that. And I think the credibility is an issue here, Your Honor, because they say the credibility is not an issue when they were talking to their clients. There absolutely is a credibility issue there. They should have seen these text messages and heard what their clients were saying and saying there's a disconnect here. And that's part of the reasonable inquiry they should have engaged in. They say that, again, they got up here and said that they interviewed witnesses. Again, there's no names. The only declarations attached to their motion, the opposition, are plaintiff themselves and plaintiff Brittany's sister. On the other hand, we have neutral parties who have come in and testified to things, saying that they observed the playful manner, flirting, and they argue that one of these witnesses apparently saw photos. That's not what she testified to. She attached screenshots of notifications and specifically said that she was not reading those. And plaintiffs goes forward to accuse her of potentially being involved in this conspiracy, which, honestly, in response to a motion for sanctions for asserting baseless allegations, that was very surprising to me, Your Honor. And we have two moms, and then one of the coaches that they say responded to them, Mr. Smoot. I addressed this on the opening, so I'm not going to go into too much detail about that. But they're going to get up here and say, people told Brittany things. Brittany's been talking to these people. Parents have come forward and said this. There's no names. The only names that they provided, again, Mr. Smoot, he came out and said, this isn't true. So they've been able to oppose this without committing to any positions, without committing to any witnesses, without producing any evidence to support any claim. The only, if the court's inclined, I understand, consent can be withdrawn at any time, 100%. Maybe that claim can go forward. Everything else, there's zero evidence of any kind against any of our clients to move forward on any point. And with regards to the counter motion, as we stated in our reply, we have no problem with redacting his name, using his initials. I find it very interesting that in arguing their motion for sanctions, they agree that there was no rule requiring that. That itself seems like sanctionable conduct to me, Your Honor. And again, it's ironic that they make that argument in response to a motion seeking sanctions for forwarding frivolous arguments. So
I think they've pretty much conceded that they're not getting sanctions. They just want the redaction.
And then I don't understand why they frame their motion as a motion for sanctions instead of simply. Your Honor pointed out that you filed an emergency motion. They reference their son's name and their opposition in the exhibits. And any person who reads this complaint is going to be able to find out who this kid is. He's on social media and Rawlings pages and things like that. So it's pretty easy to figure out who this kid is. We didn't intentionally name him to cause him any distress. We have no problem moving forward with redacting his name, but the counter motion is frankly frivolous.
Okay.
Thank you, Your Honor. Louis Gazda again on behalf of Mr. Stiles. I would, of course, echo my co-counsel's response or arguments. But one thing I do want to point out, Your Honor, is we were just informed, and as is indicated in the declaration of Marjorie Hoff, that she did do a slew of investigation. That according to her, she came up with a bunch of evidence. And what's important about that, Your Honor, is that Rule 11 says that the factual contentions have evidentiary support, or basically, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. So she says she's already done the investigation, she's already done the discovery, and she has this. Well, if you have it, this was the time to bring it forth, because that's what the rule says. If it has evidentiary support, bring it, or if it doesn't, say that you expect to have it. And that's not what's said against Mr. Stiles, Your Honor. They don't say that, oh, we're going to have evidence. They say they have evidence. Well, this was the time, according to the rule, to set forth what that evidence was. If you believe that you need discovery, then say so. They didn't say that as to Mr. Stiles. So according to plaintiff's own counsel, they have the evidence. They have evidentiary support for these factual allegations. Well, this was the time and place per Rule 11 to provide us with some of that. And they failed to do that, Your Honor. They failed to present any evidentiary support. Therefore, I believe that our motion is warranted, Your Honor, as to Michael Stiles.
Your Honor, and I'll be brief because I think plaintiff's counsel's response relative to my client was very brief. I think I'd start again with the notion that my client's named as having defamed Ms. Robertson and disseminating. When you review what we've provided, Your Honor, and I stated this, the dissemination and defamation that occurs is from Dr. Robertson to my client, period. End of story. The only way my client finds out is Dr. Robertson disseminating it to him, asking him to keep it in confidence, which he does. And then there's a subsequent conversation 9 months later, when he actually says, Kody still does, my client says to Dr. Robertson, Kody still doesn't know that I know. That is almost contemporaneous, 6 weeks prior, 5 weeks prior to the filing of this complaint. How then could you possibly have reasonably maintained, when you have these text messages in your possession, because they are your clients, that my client was participating in this dissemination the entire time? It belies logic. And they had absolute basis to know this was the case and just either didn't review it, turned a blind eye toward it. I can't really fathom it. And then the next piece, which plaintiff's counsel I think misses, is it's not that my client's angry he's being sued. It's he's angry that he was lied to. He specifically states, I asked you, Kody, did anything occur? And you told me no. They had that in their possession when they received the safe harbor. Again, did they alter their position, modify their claims, and release my client from this litigation? No, they didn't. I think right there, Your Honor, those two pieces link up to show you they had actual knowledge that they chose to ignore. And they chose to drag my client in here, have him spend, I'm not an inexpensive attorney, Your Honor, a pretty substantive amount of money for me to be here to defend this. And in reality, they had at their disposal everything they needed to know about my client. And again, I applaud plaintiff's counsel for not going into lengths because I don't think she can. I think she knows well enough to know that look at what she has and it's not there. I think at least with respect to my client, Your Honor should strongly consider Rule 11 sanctions. I think, as we've pledged, you can consider this under Rule 12 to dismiss my client altogether, and I think you ought to consider that. And at a minimum, Judge, if you're not inclined to do either, I think a strong admonishment to plaintiff's counsel about the path they intend to take forward, the significant cost. You're obviously well aware there's going to be countersuits for defamation that are going to, and so I think you can, at a minimum, a strong admonishment. But I believe for my client specifically, sanctions under Rule 11 being appropriate, if not, an outright dismissal under Rule 12. Thank you, Your Honor.
Okay, parties, thank you. First of all, thank you very much for all the briefing. Thank you very much for the argument today. Really excellent argument by all counsel. And let me tell you, defendants, you all in arguing gave me a lot of things to think about as I was sitting up here. One of the things I want to say before I get to my ruling is I made a very thoughtless comment earlier, question, when I asked defense counsel if he had ever been in a fraternity. I want to clarify, I did not mean anything untoward towards members of fraternities. My own significant other was a member of a fraternity, and that was an incredibly thoughtless comment by me, and I apologize. Now, let me get to my ruling. I'm going to deny the motion. My original inclination stands, and I'm going to give specific reasons why I'm denying the motion. I'm going to give them to each of the three movements. As to Mr. Gorden, I think Mr. Gorden's, to the extent the motion is about Mr. Gorden individually and the allegations that the Robertsons make against Mr. Gorden, I think that Ms. Robertson's declaration and testimony alone forms the sufficient basis of evidence for counsel to have made a reasonable inquiry under these circumstances. And I also think that further discovery is going to elucidate the allegations here. As to Mr. Stiles and then Mr. Inouye, I agree that it's a closer call as to your clients, especially I think Mr. Inouye here. But I think there is enough in the declarations from the Robertsons that have been provided that it forms the basis to support that counsel made a reasonable inquiry under the circumstances. And by circumstances, I mean, we're dealing with a situation here where the direct evidence, at least of the sexual assault, is going to come down to a he said, she said, okay, testimony. There's going to be circumstantial evidence, and that's what I was alluding to earlier when I said, look, the text messages and the messages that show that this was possibly a consensual, relationship, that's going to be circumstantial evidence. But the circumstances is that it's exactly as plaintiff's counsel said. We don't have all of those text messages right now because they were naturally, in a way, deleted during the course of this relationship. So I'm denying the motion as to all three defendants. I am going to say this, and I thought this when your motion was first filed. First of all, you have a number of other remedies. I don't want to be up here giving you legal advice on how to do your case, but I am going to say that under NRS 18.010B, when the court finds that a claim was brought or maintained without reasonable ground or to harass the prevailing party, the court can award fees. And the court is to liberally construe this provision as specifically stated by the legislature in the provision. And so what I'll say to plaintiffs is this. You're going to have an opportunity here, unless there's something else filed in the meantime that changes this court's position, to gather your evidence. But I would also say that plaintiffs need to tread very carefully here, particularly with Mr. Stiles and Mr. Inouye, because I will consider a motion later on in this case. Please do not file your 18.010B motion next week just because I'm talking about it now. But later on in this case, I will consider an 18.010B motion and whether or not, evidence was adduced that allowed the plaintiff to maintain their claims with reasonable grounds. Okay? And then, you have, I know Mr. Inouye's counsel asked me to consider this under Rule 12b-5 standard. I don't have that motion in front of me. That's a different way of looking at a case.
You gave your honor some case law to it. I understood it was stretching the bounds a little bit, but I'm an attorney. That's what we do.
Yeah. I completely understand that. That really doesn't give the plaintiff a fair opportunity to respond. So you're going to have an opportunity. You're going to have to. I'm going to order you all need to respond to the complaint within 2 weeks of today. So by the 22nd, you need to get your responses into the complaint, whether that's a 12b-5 motion to dismiss. If you think, under our very liberal notice pleading standards, that you can, prevail on a 12B5 motion, then, file your 12B5 motion. You have, or, answer the complaint, or if there's some other intervening motion that I'm not thinking about, you can file that. But I do want to get this case going. On the motion for sanctions, I'm denying, as I indicated, both requests for sanctions for both the use of the child's full name and for use of the phone numbers. I am going to, under the circumstances, given that the motion was not filed on an emergency basis, I am not going to do anything retroactively regard to what's already been filed and what's already been publicly disseminated. But moving forward, any minors under the age of 18 who need to be mentioned in this case need to be mentioned either under some type of pseudonym or by their initials. Initials are probably the easiest way forward. I want to talk about something else since I have all counsel here. We're not ripe yet for discovery because the pleadings haven't closed. You haven't had your early case conference. Defendants, when you do have your early case conference, presuming you're still in the case, one of the things that you should think about or consider thinking about is whether or not discovery needs to be staged in any way. In this case, that is something I will consider a request for. I'm not saying I'm granting it. I'm not even saying I'm inclined to grant it. But I'm saying I think that needs to be a part of the discussion in this case as to whether or not discovery can and reasonably should be staged. The other part of discovery I'm going to talk about is that clearly this case is going to involve electronic information, including perhaps forensic collection of electronic information from cell phones, from tablets, from the cloud, from whatever else, stores, text messages out there. You all need to talk about an ESI protocol, okay? How you're going to collect that information. And by the way, to the extent the parties have not, your obligation to preserve that information, by the way, that has been triggered and come and gone. So to the extent your clients have not preserved their electronic information, you should get on that right away. And that applies equally to all parties. That's plaintiffs and defendants here, because text messages are so much at issue. Text messages and direct messages, I think DMs are at issue in this case as well. And so you've got to preserve the phones. You've got to preserve the data on the phone. So the physical phone itself, you got to preserve the data on the phones. If there's a link, for instance, to iCloud, because I think we're dealing with a lot of Apple iPhones here, you got to preserve what's on the iCloud. If suddenly I hear that somebody had, a terabyte of iCloud storage, and then suddenly that storage went down to, 0 gigabytes, and now nothing's being backed up, I'm going to have a problem with that. And then one other thing that you all can think about, given the nature of this case, I'm inclined to keep discovery. So you all talk about at the early case conference and decide whether or not you want to go to the discovery commissioner or whether or not you all want to stay with me. You gain a little time by staying with me. So that's something to think about as well. The court is going to enter its own order on this case. So no party needs to prepare the order. Otherwise, I think if any defendant answers, you'll be right then to hold an early case conference. Okay, thank you very much, everyone.
Thank you, Your Honor.
I appreciate it.